Good morning, everyone. Good morning. Good morning, YouTube, Facebook, Instagram. Come on in. Come on in. Um, I'm happy to have you guys here. If this is your first time, definitely comment in the box. Let me know it's your first time so I can give you a shout out. Let me know where you're tuning in from, regardless of where you are, so I can give you a shout out. Good morning, Tolbeck. Good morning, Yosola, Miss Mabella. Um, Good morning, Napoleon. Good morning, A. Lopez. Holla Moore from Texas. Good morning. I know it is so hot in Texas right now. If you guys on YouTube can see me, comment in here and let me know that you can see me from YouTube, just so I can know, or you can put a wave so I know that you can see me from YouTube. I'm Napoleon Mantelovic. This is your first time. Good morning. Lots of first time. A Thug Life from Jamaica. Welcome. Kofo from Texas, welcome. So many first timers. Dimple says you look pretty. Good morning. Thank you so much. Always, Jojo, welcome. Cleveland, Ohio in the house. I see you. Let me quickly introduce myself. My name is Aisha Chidole. I'm an immigration lawyer and I present clients with their immigration matters. Family-based cases, complex humanitarian-based cases, requests for additional evidence, notice of intent to deny citizenship, you know, conditional removals, waivers, all of that good stuff. I can help you with that. To schedule a consultation, you can call 407-995-6567. You can also send a WhatsApp to 404-333-8751. Myself or any of the other associates at my firm will be happy to talk with you and see what you qualify for and how our firm can help you. Today, I don't really have any topics. I've just come on live because I have a short time, but some time to chat with you guys. So feel free to jump in and ask your questions. I'm happy to deny it. I'm happy to answer as many of them as I can. I see somebody here is asking, I-485 was denied. Can you reopen the case? Yes, technically you can. Well, not reopen, but you can request for one. But typically, before we make that kind of analysis, it's always a good idea to consult and let's see the reason for your denial. Because depending on the reason for your denial, there might be a possibility that it might be better that you actually file a brand new application as opposed to doing a motion to reopen, a motion to reconsider. So it really depends on the reason why your case was denied. If let's say your case was denied for an I-864, meaning an affidavit of financial support, for example, it wasn't done correctly or whatever the case may be, you could technically do a motion to reopen, or you could just file a new application. That will depend on also, do you need to work, or are you okay to wait for them to make a decision to reopen or reconsider your case? So there are just so many variables where you can't just give one answer without really knowing the personal circumstance of that friend, of that denial. Your Owen says, hey, from Orlando. I hope you guys are doing okay in Orlando. Like, how was the hurricane? It came through in Georgia, but it was just really heavy rain here. So Toya from YouTube says, what is your advice on advance parole for someone doing VAWA? So I can't give you legal advice because you're not my client, but I can definitely educate you on advance parole. So if you do apply for VAWA and you attach an adjustment of status application with your application, you can request advance parole. Now, if your question or what you want to understand is if you can travel or not, I always say that the answer to this depends. It really depends on what your immigration history is. Have you previously filed an asylum? What stage is your case in? So all of that determine whether one can say, it's okay to travel. But if, let's say, you've never ever put in any kind of immigration application, self-petition or otherwise anyone has never filed for you, you have a clean VAWA with adjustment of status application that you put in, and then you get advanced parole. In those cases, definitely it's okay to travel. You definitely don't want to travel towards 6 months before the expiration. Advanced parole these days, you get them in conjunction with your work permit, which are being given for 2 years. So you want to try and make that trip earlier. You want to make sure that when you're traveling, that you're taking all the required documentation, showing that you have a pending case, a pending adjustment of status case, and just be prepared that it's possible that sometimes you might be put into secondary review. If your circumstance is not that and it's a different circumstance, definitely would need a consultation to understand your circumstance before I can speak on it. How long does it take to get a green card through VAWA from start to end? So getting a green card through VAWA from start to end, the timeline can vary. And this is with any immigration case at all. So whenever I give timelines, the timeline is really just the average. There are going to be some people that there's, end up being quicker or end up being longer, depending on different variables in their application. But the average person that submits a VAWA application with an adjustment of status, which is a green card application, you're looking at anywhere from 2 years to 2.5 years for a VAWA decision to be made. And from that time, anywhere from 1 to 6 months to get your green card. So in totality, it could be, a total of 3 years or 2.5 years, depending on where you fall. And this is the average person. We have seen some people get these done earlier than a quicker time, just as we've seen some people take longer. So it just really depends on your particular case. Rachina Ibaka says, hello, Lawyer Aisha. This is Alfonsi. Thank you for everything. You're so welcome. Hey. Augusta says, what are the fees for filing VAWA? Well, if you're submitting an I-360 VAWA application, there is no filing fee to USCIS for that. You only pay for the adjustment of status portion of the application. Hi from Maryland. Hi from St. Petersburg. Pina Yale says, you look so pretty. Thank you so much. Good morning, Tina Francis. Good morning from the A. Issy Sparks, Mississippi, North Carolina. I mean, Massachusetts, you guys are like all over the world or all over the US. King Shaky says, I need your help, but I need your business number. Our number is 407-995-6567. If you want us to call you, you can send a WhatsApp to 404-333-8751. The number is also in my profile on all my platforms. Please, these two numbers are our only numbers. You should not be paying anyone for a consultation fee via Zelle or Cash App, because that person is most likely a fraud. They're most likely not our firm. All our payments go through, a proper platform and stuff like that. Someone is asking about fiancé visa process. Okay, so just real quick, I'll touch on that real quick. And as a matter of fact, speaking of fiancé visa process, I'll give an example of one case that we just got approved, and we're waiting on the consulate interview next month. So typically with the fiancé visa, some things that you have to show. One, you and your fiancé cannot be married, right? You cannot be legally married. You also have to show that you are a U.S. citizen. You also have to meet the income requirements. While the income requirements for a fiancé visa is less for applying for a green card, when I talk with my clients, I always recommend that they strive to make sure that their income surpasses the minimum poverty guideline requirement for the green card. The reason why is because when you apply for a fiancé visa and they get their fiancé visa and come here, you got to marry within those 90 days and then file for them. So at that time, you're going to need to show that higher 125% income. So it is a good idea to just be prepared, as opposed to you bring them here and then you're stranded, you can't apply for adjustment of status and all of that good stuff. So as I was saying, so you have to be a U.S. citizen, you have to meet the income requirements. You also have to show that you have seen your fiance at least once in the last 2 years. So there are typically some exceptions to this, and we actually just got one of our clients approved for this. And the exception is if there is an extraordinary circumstance that has not or cannot allow you to see that person, or has not allowed you to see that person in 2 years. So using this case pattern scenario of what happened with a client of ours, where the person was in love, with someone from Ukraine. And, as you guys know, unless you've been living under a rock, there's political turmoil and unrest and war between Russia and Ukraine right now. So from a travel category risk to United States citizens, it's not safe for that person to go. So that person had to leave Ukraine and go to, a safe location. And so we were able to present that argument saying, it is too risky for a US citizen to put themselves in that danger to go there to visit the person. But here's all the proof that they're in a legitimate relationship and they just want to be together, and he just wants to get her out of safety so they can marry. And so those clients were approved for their I-129F, which is the actual original petition that you submit here in the US. And then once that's approved, it moves over to you filling out the application for the person outside the country and scheduling the interview. So we've just scheduled the interview and we're just waiting for the interview, which, I believe by God's grace, it will go well. Katie says, how long after USCIS, how long does USCIS normally take to update you that they've received your evidence? Sometimes they do, sometimes they don't. Meaning they don't necessarily update you, meaning they're not sending you an email, they're not sending you a letter. What it is that they will typically just update it on your USCIS online account. So like if you type in your receipt number, you may see it on there saying that, we received your RFE. But I don't want you to hold on to that and say, oh my gosh, it's not there, and so they didn't receive it. That's why if you are ever filing something by yourself, which you shouldn't, but if you are, you always want to make sure that you have proof of delivery. So you always want to make sure that you pay enough postage where they can provide proof, right, that your item was delivered. And as long as you have that proof, USCIS can never make the argument that they never received your response. So hope that answered that for you. All right, so okay, let's see. Let me scroll. I just missed my spot. There's so many questions on Instagram, so I'm just trying to scroll and try to take them in order as much as I can. Oh my goodness. Blue Chillian says, my wonderful lawyer, I have not seen you online for a while now. What are you talking about? I was online on Tuesday. You need to log on so you can see me. I have a question. Can my nephew and my sister come visit me in the US? Sure, as long as they have a visa or they belong to a country that maybe has a visa waiver program. King Sixer says, thanks for your good information you give on social media. You're very welcome. One of my missions is to, make sure that I'm educating a lot of immigrants about what benefits they have. When I came into the space, I realized that a lot of, especially English-speaking immigrants, didn't really know much about all the different ways in which they could adjust their status or get their green card or file for different things that they qualify for. So a lot of times people are just suffering, in silence, or just thinking, well, I'm just going to marry somebody and just do it, when there are just so many different ways in which you can get your paperwork legally. And so when I come here, I want to educate, and, anybody, whether you speak English or you speak Spanish or you speak French or whatever you speak, so my goal is to educate people, and of course, people who also, look like me as well, on what the processes are and how to get themselves legalized. Is it possible to fix status from K1 after overstay? Not married yet, but now we're ready for a family petition. Is that possible? If yes, I want you to represent me. Sammy, no. So if you came here on a K1 visa, which is a fiance visa, you must marry the person who brought you here. If you've not married her within 90 days, you need to marry that person. I said her, him. You need to marry that person. If it's after 90 days, you just have to start your whole process again. Now you got to do your I-130 and the rest of the adjustment of status. In that case, we can represent you. Now, if you came here on a fiance visa and you and that person didn't work out and then you married somebody else, you cannot do an adjustment of status. You will not be eligible for an adjustment of status. You would have to go back home and consular process after you get like a waiver approved on your behalf. What do I do if I received expedite denied for travel parole? So your expedite request for travel parole was denied. Then you just kind of have to wait for your travel parole. I mean, I don't know how you applied. Did you go into the office and explain and provide evidence? So again, this is one of those things where there's so many variables. I don't know what you submitted to show them that. Now USCIS is given the ability to actually schedule online for emergency travel parole. So you can actually schedule emergency travel parole, go into the office, and then present your case as to why you have an emergency. So we'll need to know basically what your emergency is. Okay, let's see what else. How long does it take to reopen a case, motion to reopen? The answer it just really depends on the case. Sometimes 6 months, sometimes a year, sometimes 2 years. It just really depends. And that's why I always say it's really important to, for me to assess the case and see, can we just file a new application and just not bother with the reconsider or reopening portion just because it's going to take a longer time. Here's an example of that. We had a client who came to us, a VAWA client who, by the time he came to us, he was denied. His VAWA case was denied. But the kicker was, at that point, he had been divorced from his spouse, his abuser, for more than 2 years. And, as you guys know, with VAWA application, if you've been divorced for more than 2 years, you can start a new VAWA application. You can file VAWA if you're divorced, but you just cannot do it after the 2-year mark of the divorce. So in that case, strategically, we knew that we couldn't present a new VAWA application, because if we presented a new VAWA application, we would get denied because he was no longer eligible. So we had no choice but to do an appeal. And by the grace of God, that client got, they reopened that case. They reviewed it, they approved him for his VAWA, and then, he never filed adjustment of status. We did the adjustment of status. And as a matter of fact, that client's results were posted yesterday, and now they're 10-year green card holders. And in 3 years, they can apply for citizenship. So that is a case where strategically it made sense to reopen. And, for that client, I believe it took about 6 to 8 months for the reopening to happen. So, just all depends. So this person says marriage-based adjustment of status, and I-130 was approved 8 months ago, and no movement on the I-485. Any consideration? I will say do an inquiry to see if you're being bypassed for an interview. If you are, can they schedule you? Also, you want to look at what's the window from a processing time. So even though your I-130 was approved 8 months ago, but how soon after? You said your prior date is March 2022. So you submitted in March 2022, and then you got approved for the I-130 in about January, since today is technically September. Yeah, so it's definitely right for an inquiry to see what's going on. So if I were you, I would do an inquiry, find out what's going on. Were you bypassed? Are they scheduling you? What's good? Terry says engaged to a Jamaican, better to marry there or do fiance visa and marry her here? The answer to this really depends on your family and your lifestyle. I would never say to someone one is better than the other, because both come with serious pros and both come with serious cons. So let's talk real quick about the pros and cons of either doing a fiance visa for a loved one outside of the US, or marrying the person that's outside the US and filing a spousal immigrant visa, which basically converts to a green card. With a fiance visa, more than likely, you're going to see a shorter timeline depending on the country that you live in. Not all countries have a shorter timeline, but some countries will have a shorter timeline if there's not a lot of active visa applications going on in that country. Using some of our demographics on here, like, Jamaica, Ghana, Nigeria, and you have longer timelines to a fiance visa, or to even any kind of interview. So timeline wise, it might be slightly shorter, but there's still a timeline. You're still looking at anywhere from 15 to 18 months for the process. Whereas with an adjustment of status, not adjustment, with a consular base of marriage, you're looking at 18 to 24 months for the whole process. Now, this is where the pro and con come in. So from a pro for a fiance visa, you're most likely going to be able to come here slightly earlier, a couple of months. If you're like, I don't really care. I just want my husband, I just want my wife here. I don't really care what we have to deal with. Let's just do the fiance visa, then do that. If your fiance or significant other outside of countries, maybe someone that's a breadwinner or someone that provides for his family or her family, or her relatives or parents or siblings, one of the things that you want to consider is, once they leave the country and come into the United States, they're not going to be able to work until they get their work permit. And for them, it might cause a significant conflict, not only for them and maybe the people they support, for you as well. If, let's say, you're not financially able to manage adding this extra person into your life. So a lot of times when we see disputes between couples, there's always a financial component as well with the fiance type visas. Where they're like, well, he's not pulling his weight. I'm just paying for this and paying for that. So if you know that your income is not going to support a new adult into your household without a person being able to work, in that case, you might want to consider doing a marriage-based consular processing, because at least when they enter into the United States, they'll be eligible to work right away. So it's really just a matter of, looking for a job and getting a job, that'll offer him a job. And then, so that's a pro for marriage-based consular processing. And then another pro for marriage-based consular processing is that once you file that way, once they enter into the United States, they're green card holders. So you don't have to do anything else again, unless 2 years later, let's say they got a conditional 2-year green card, then 2 years later, you're now filing for, removal of conditions. But if they got a 10-year green card, then they're done until they're applying for citizenship. Whereas these are the strict parameters of a fiance visa recipient. Once they enter into the US, then within 90 days, you must marry. After you marry, within those 90 days, you must then file for adjustment of status. If neither of those things happen, then that person is SOL, basically. They cannot get their green card. They cannot, go and remarry somebody else and think that they'll be able to get their green card while they're in the United States. So that is a very strong pro for a marriage-based case. And, again, with the fiance visa, when you enter, your process is not done. When you enter, you start the next round of the process. But the pro is at least you get to be together. So to be honest, the only pro, in my opinion, for a fiance visa is that you get to be together quicker, but everything else is basically a nuisance. So from a strategic perspective, hopefully you're able to figure out which one works. Sometimes some people are like, maybe the spouse is pregnant, or maybe they have a health condition, or they're pregnant and they have they need to be put on bed rest because they're high risk. In those cases, I'm a strong proponent for doing that fiance visa and getting them here, so you can have someone to support you while you're here, while you're pregnant. Okay. Um, I've been waiting over 1 year to get an interview date for I-130 visa. Paperwork has been accepted and approved by National Visa Center. So what you mean by your question is that you've actually been approved for an I-130, because you can go through a National Visa Center or get documentary qualified if you've not. So now you're just in a waiting window. And if you just heard me earlier, I just said, I don't know if you're from one of those countries. Honestly, like getting that, once you get into queue for certain countries, the wait is long. The wait is long. It just depends on the country you're from. So, one of the things is that, your attorney, or if you want to hire us to do some inquiries directly with your consulate, or embassy, we're happy to do that. Sometimes we harass them. We just keep emailing them until they find a spot for our clients. So that's where having someone to advocate for you helps. Okay, you mentioned in a previous, I guess, live or post that if you ever checked on a work document that you're a U.S. citizen, you will get a permanent bar from becoming one. How would immigration know that you've done this? Okay, so listen up, guys, and listen good. So one thing you have to understand is that this is the United States of America. This is the greatest country in the world. We can argue it nonstop. This is the greatest country in the world. This is the greatest country with intel and all the information they have. Just by the virtue of the fact that you might list certain employment that you've worked there, USCIS is able to do your E-Verify. They're able to look at your I-9 records. They're able to see that. I always say, a U.S. citizen application, the application itself is one of the easiest forms to fill out, but it is the most difficult process to get approved for, because this is where whatever you've done to get your green card or whatever it is, at this stage, you cannot hide it. The amount of investigation that is done before they can grant you that citizenship, you can't take it lightly. And the reason why they do that is because once you become a citizen, then there's not much else that can be done to take that from you. So USCIS will know, especially if you have listed, let's say, for instance, you say, oh, like sometimes, in a consult or whatever, I may ask, did you work under the table? And they're like, oh, well, I used to work at like Walmart or whatever. There's certain companies that, based on the size of the company, that they must follow E-Verify or I-9 verification. And once they have that, I immediately get nervous because I'm like, okay, how did you get the job? How did you stay in the job? Because those jobs should be verified, because if you lie about it, USCIS is going to know, because they do massive, and for those who have been caught doing this, they can tell you, massive investigation before they can recommend you for naturalization. So yeah, that's how they know. Don't do it. It's not worth it. There are many ways, that immigrants get jobs without having to write their U.S. citizenship. Do not make a false claim to U.S. citizenship. There are very few things that can allow you to have a permanent bar in that, other than U visa, which really, honestly, I don't wish on anybody. Like a U visa is where basically you've been a victim, witness to a serious crime, and you're willing to cooperate with law enforcement. So you don't wish someone to be a victim or witness a serious crime when they're committing working with law enforcement. But that's literally one of the only ways that can be forgiven. After my interview in 2019, I haven't received any update from USCIS. I think that's what you're trying to say. Does it usually take that long to hear back from them? No, Ladybug, it does not take that long to hear back from them. Time for you to contact an attorney, because that is a really long time. They've rescheduled my interview over 3 months now, but I haven't received any notice that my status didn't change from interview was scheduled. Yeah, a lot of times USCIS just doesn't update the stuff online, so I wouldn't really worry about the stuff online. I would say 3 months is not really a long time to start panic. Maybe to start panicking. I mean, I would say wait 6 months. If after 6 months, then you can do an inquiry to see what's going on. Okay. How long does it take to receive a work permit? I filed for marriage-based paperwork in March. Most people, it takes anywhere from like 4 to 9 months. So you'll probably fall into that window. We're definitely seeing a lot of like 4.5 to 6.5 months for a good amount of people, but 4 to 9 months is what I would say is average. Um, Nurse Bay says, have you seen instances whereby marriage-based AOS I-130 was approved without an interview 8 months ago and I-485 is still pending? In our firm, no, unless this, and actually that brings me to talk about something, unless the person filing is a green card holder. So Nurse Bay, I don't know if that's the case for you. If the petitioner, which is the person that's sponsoring you, is a green card holder, expect a wait. So bad news for green card holders filing for their spouses and children, because basically the September bulletin has changed. And for some people, you're going to probably wait as long as 5 years, to get it. If you're doing it outside the United States, and if you're doing it within the United States, even though we're going with date of filing, you can no longer file your adjustment of status at the same time. This is a perfect example of when we say, myself and other immigration lawyers say, you snooze and you lose. Immigration is such a fast changing area of the law, literally, that you can have printed out something ready to submit and they will quietly announce a change. And you have to reprint the stuff again or change the forms or change whatever. And this is how this has been quietly changed. So the visa bulletin changes every single month. We don't know what October is going to be, but it is not looking good. And I remember in 2019 when prior to 2019, it used to be a 2-year wait, for green card holder spouses and children. And then, like maybe end of 2019 or 2020, it became current. And I used to say this all the time, file, 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 and I'm sure there are people just sitting down or dragging their feet and they didn't file. And now they're no longer eligible right now. Not that they won't be eligible forever, but now it's going to take longer. So similarly, if visas are no longer current and Nurse Bay, you're one of those who was a green card holder who filed for you, they cannot approve your I-485. So they'll basically hold the application and allow you to continue to work and travel until a visa becomes available for them to approve your green card. And so, I want you to comment and tell me if the person petitioning for you is a green card holder, because that's the only case in our own firm that we're seeing that. If that's not the case, then we definitely need to see what's going on. There might be something in your 485 that makes you inadmissible, or they're doing investigations or it's causing them to do investigations. So we want to take a look at that and see what's going on there. Sure Baby says, can you marry your spouse while your citizenship application is in process? You can. You're just going to have to amend that and bring the marriage certificate to your interview. And if you do get married, let's say you naturalize and you get married, let's say they recommend you for naturalization and you get married, because your application is an active application, you want to bring the new marriage certificate to your naturalization ceremony so that they can reissue the correct marital status on your naturalization application. Okay. IRD Realtor says, do I file an I-130 or an N-400 for my underage kids that live in Nigeria if I'm a U.S. citizen? The answer really depends. Were you a U.S. citizen before they were born? If you're a U.S. citizen before they were born, you don't need to file either of those two applications. They will have to just do a birth record, birth of U.S. citizen abroad, which they would have to schedule with the embassy, and you can do that for them. If they were not U.S. citizens, if you were not a U.S. citizen when they were born, then you need to file an I-130 for them. Once they become green card holders, if they're under 18, then they can derive citizenship through you as long as you meet certain other requirements, including, them living with you and all of that good stuff. An underage child cannot file an N-400. You can only file an N-400 if you're over the age of 18. But because you asked this question, it tells me that you should probably not be doing this yourself, because there are, again, many particularities to this. So definitely consult with an attorney, or my firm would love to help you do it the right way. It's Charm says, will your case be affected if you got a work permit and you didn't start to work right away? Absolutely not. That would be ridiculous. A work permit, not only asks for you to work, it also asks for you as your identity, and a lot of times as your travel permit card as well. And so sometimes some people are not trying to work, they just want that, especially like for the kids, or maybe people, their spouses work and they don't need to work. So them giving you a work permit is not, nobody can force you to do labor. It's just them giving you a work permit so that if you want to work, you can work. And nobody can control when someone finds a job. C Beauty says, what's the number for consultation? I'm joining for the first time. Well, welcome. You can call 407-995-6567. Also send a WhatsApp if you want, 404-333-8751. Guys, we do not take calls on our WhatsApp. You have to use the call number. The WhatsApp is if you want to give us your number to call you, or you want us to send you a link where you can book the consultation directly by yourself. Kevin Barrett says, how early can a person reapply for their 10-year green card? How fast can an attorney get the green card? So the first question is, why are you reapplying for your 10-year green card? If you have a 10-year green card, you're typically eligible for citizenship within 5 years, unless there's something else that makes you not meet the naturalization. So the first recommendation by most attorneys is to apply for naturalization so that you can get your citizenship. Okay. Once you get your citizenship, then nobody can ever take that away from you. As a green card holder, anything can happen. My favorite example of always using is if you guys watch Real Housewives. I used to love Real Housewives. I think I've outgrown them, so I don't watch them as often. But if you know Real Housewives of New Jersey, Teresa, I'm sure you guys know her. She was married to Joe Giudice. He came into the United States from Italy at the age of 2. He was a green card holder. His entire family was U.S. citizens. His wife was a U.S. citizen. His 4 children were U.S. citizens. He was married to his wife for probably 18 years, or 19 or 20. No, I think 18 or 19 before they got divorced. So at any point, he could have filed for citizenship, either through his parents or through, either before he, got married to her once he turned 18, or through his wife. But he never thought it was something that mattered or that really cared. Like I'm a green card holder, whatever. And I hear that a lot, especially from Canadians or people that have more of a flexibility to come and go out of the United States, right? Where it's like, well, I don't really care about U.S. citizenship. I just need a green card or whatever. And then what happens? Bad luck strikes. He's arrested for tax evasion or tax fraud or something like that. And he's put in jail for like 48 months. And after that, he gets deported, right? For a crime of moral turpitude. Do you understand how painful that is to be deported to a country that is not home to you, right? He got deported to Italy. This man has not lived in Italy since he was 2 years old. He's in his 40s. So this country is really his home. But even that, and having an entire family that are U.S. citizens, could not save him because of the good moral character. I mean, one could argue that the judges maybe had made they were very punitive in how they sentenced him, maybe to show it as an example to people on TV or limelight. But the point is, if he was a U.S. citizen, he would have served his time and come out, and maybe his marriage would have worked, or maybe he would have had that time with his children. before they are, they all grew up or went to college or whatever the case. So the long and short of this is, if you are eligible for citizenship, you need to be filing for citizenship, not renewing your 10-year green card. So, Kevin, your further question says, would you advise applying citizenship within 10 months left of a green card before the renewal deadline? Absolutely. And even if you pass the renewal deadline, your application for citizenship will act as an extension of your green card. So please file for citizenship, Kevin. And nice to see you. What is your VAWA approval rate? I will say that our VAWA approval rate is pretty high. I don't have any statistics offhand right now, but I can tell you emphatically that the only times that we've gotten VAWA cases denied is when a client has an unauthentic divorce decree. That is something that we cannot cure. And that is why, I try my best, even though some people take it personal and think that I'm picking on them. I'm not picking on anybody. I'm trying to help you guys to tell people, get a valid divorce. You cannot marry somebody else without making sure that the divorce that you're filing is valid. Before you finalize divorce documentations and go remarry somebody else, speak with a divorce lawyer. I'm not a divorce lawyer. I'm an immigration lawyer. Speak with a divorce lawyer, especially if you're from certain African countries, and make sure that you are following the rules of how to do a proper divorce in those countries. If you and your spouse or your spouse that you're about to divorce live in the United States, there's absolutely no point of filing a divorce in your home country. You file the divorce here. That is the only time, and I can count it all in this finger, and that should tell you what my record is. As you guys see, I do a lot of VAWA cases, and I can count the VAWA denials in this finger, and those are the reasons why. So hope that answers your question. All right. Okay, so John says to answer my question. Let me see your question, and I gotta head out very soon. When my VAWA application reads, your case has been transferred, please, where is it transferred to? I mean, which center? I don't know because I don't have your case in front of me, but I suspect, John, that you filed in Nebraska. And so that is something new as of, was it late last year or early this year? I don't know if my timeline is jumbled right now, but when Vermont became overloaded, which was the only center before that used to review VAWA cases, they started having people send their original applications to Nebraska. So sometimes you will see from Nebraska where it'll tell you that your files have been transferred to Vermont, who does all the reviewing and all of the finalization. So that's probably what happened with you, but that's not something that I would be concerned about. That's fine. Okay. Kevin says, Madam Counselor, we truly appreciate you. I also appreciate you. Blessings to you. Thank you. And thank you, Kevin, for always supporting me. I always see your very lovely and very kind comments, and I really appreciate that. All right, guys, I'm going to take two more calls, two more questions, and then I got to go. Alana says, good morning. Are you able to obtain your driver's license if you overstayed your visa for 5 years and then have a social security number? The answer is going to depend on the state that you're in. Some states will allow it and some states won't. So what you want to see is what is the rule in your state to get a driver's license, okay? William Steneka says, how can I make an appointment to speak with someone in regards to my fiance who resides in Nigeria? Congrats. Call us 407-995-6567, and we can help you with that. Let's see. After a VAWA approval, is it normal not to hear from them after months to get the green card? Yeah, well, like I mentioned earlier, it can take like 6 months. So, you're fine. If after 6 months, we'll usually try to do an inquiry if you're with our firm to see what's up. Okay. Okay, one more. This is my absolute last one. that I'm taking. Mm, okay. It's like you guys are typing and it keeps taking me back up. So, okay, my last question that I'm taking. My friend got her approval letter, but her green card went to the wrong address. USCIS is fault because all other documents went to her address. Now they're telling her she needs to redo her I-190. What can she do? She has to, unfortunately. The only difference is that if you have clear evidence that USCIS made the record, then you don't have to pay for the I-90. But that's the only way to get a new green card. All right, guys. I enjoyed this chat. I'm truly going to try my best to be coming on live on Tuesdays and Fridays. I'm gonna have like an announcement and a reminder. So I'm gonna do Tuesdays and Fridays. Generally somewhere between 10:30 on Tuesdays. Fridays probably like 10:30 to 10:45. So save that. So if I didn't get your questions answered, happy to answer them. If you have pressing needs, you want to get your immigration case started, call the office, guys. I'm telling you, we don't know what's going to happen in the next year and a half with immigration. We don't know who's going to be the president. And let me tell you guys, if you have not been paying attention, immigration is one of the biggest points of contention for any presidential race. And a lot of changes happen then, which can be to your benefit or to your detriment. So whenever you qualify, you apply. You don't wait. Okay? All right, guys, my number again is 407-995-6567. You can also send a WhatsApp, 404-333-8751. All right, guys, have a great